consolidate and become a customer of Sac County Water Agency's East Walnut Grove system. Locke has submitted construction plans, which have been approved, for a pipeline to run from East Walnut Grove to Locke. Locke must enter into a service agreement with Sac County Water Agency to become a customer so that construction can begin. So this is just a brief overview. This is the river. This is River Road. The system's a little bit further down where the wells are for East Walnut Grove. The pipeline will come, I believe, up Mueller Lane, and I'm sorry I don't have construction photos available, but it will come up the pipeline. It'll cross over the levee, and it'll connect right about here where a meter will be put in. The meter will go ahead and then is what Locke will be charged based on water usage. It will be a combination of commercial and residential properties, and Locke will then become a customer of Sacramento County Water Agency. Once the service agreement is signed, construction can begin. So that concludes a brief overview and my presentation, because I was told it was only going to be a couple minutes, so I did leave some time for questions. If anybody has any, can you please raise your hand?
Okay, I have a question. So the construction hasn't started yet, right?
That is correct.
Okay, I understand. All right. For the board members, this your please ask your questions. Board okay. Member Heath, please.
Thank you, Chairman. Question: will there be a single meter for the entire community, or will the meters be placed per building or per residential unit? How will that be done?
So at this time, there will be one master meter that connects to Locke from East Walnut Grove. During a later phase, Locke has the ability to put meters on each individual service connection, but that is not part of the current construction project.
So how would water charges be allocated to the various residents and businesses in Locke?
So there's, I believe, my understanding based on the service agreement that has not been signed, so I cannot speak completely to that, but there will be a commercial charge for commercial buildings and there will be a residential charge.
Just a flat charge per
connection.
Thank you. And if the plans have been approved, I'm just curious, what is the what are the next steps to starting to do whatever interconnection would be needed?
The service agreement needs to be signed by both parties, both Sac County Water Agency and Locke. Once the service agreement is signed, the Sac County Water Agency will take that to the Board of Supervisors. There is about a 45 to 60 day window to get on. So it's May, for example. So once the agreement is signed, then they can go ahead and take that item to the Board of Supervisors, who would then vote on it. Once that item has been voted on, and I'm assuming approved, construction can begin.
And the agreement, is that a negotiated agreement? Is this like a form agreement with the county? What does this thing look like?
The service agreement is how much will be charged, where the meter will be, who will be responsible, up until what point. That is really better questions for Sac County Water Agency, as they are entering into an agreement with them. I represent Environmental Management, who is the local regulator.
Okay. So we should to get a copy of the agreement, we should go to the Sacramento Water Department?
Sacramento County Water Agency.
Water Agency.
Correct.
Okay, thank you.
You're welcome.
And thank you, Member Heath. Okay, Member Warsaw, please.
Thank you, Megan, for your presentation. Could you tell us how long, it sounds like we're just waiting for signatures. How long has the status been like this? How long have we been waiting for these signatures?
Well, it's not so long that you've been waiting for signatures, but I had to go back and forth between Sac County Water Agency's County Council and then also Locke Water Agency's County Council. There have been some iterations, as it does change on a calendar year and a fiscal year also funding. So it's just logistics like that. So my understanding is that signing of these documents should be coming up pretty quickly so that it can be taken to the Board of Supervisors.
Member Prassa, please.
Once everything is signed and approved, approximately how long will the construction take?
The construction, probably, best guess, you may run into problems, so don't quote me on this. But I would say, probably 15 to 18 months.
Okay.
As they do have to, construct that pipeline across the levee and everything. So it will take some time.
Okay, thanks.
You're welcome.
Okay, so if no more questions from the board members, public comments, 2 minutes.
It looks like that has a question.
Member Kirk. Member Kirk?
Okay, so the grant is just to run the master meter, correct?
Well, the grants begin with the feasibility study to determine which best option would be available for Locke, whether it be consolidation, drilling a new well, or treatment. And based on the feasibility conducted in 2010, this was the best option.
Okay, so then the cost for the actual construction to the master meter is paid by who?
By the grant. That's part of
the grant. Okay.
Yes.
And then then the Locke Management Water Company, they would have to, if they wanted to put individual meters on, there would be a charge from them from the hookup or a charge from Sac County Water for individual hookup.
The distribution system will still be owned by the Locke Waterworks Company. So it is at their discretion if they would like to apply for another grant to put a meter on each connection. But that is not part of the current project.
Okay, and then do you know about how much each connection would cost?
I do not.
Okay, and then would the Locke Management Association be billing the customers, or would it be the Sacramento County Water?
It would be the Locke Water Company, because Locke would be a customer of Sacramento County.
Okay, and so they would actually send bills out to the water bills out to the property owners, correct?
That is my understanding, yes.
Okay. All right, thank you.
You're welcome.
Thank you, Member Kirk. Okay, any questions from the public? If no, so I take the opportunity to thank Ms. Floyd. I mean, this is a very nice presentation. You make a special PowerPoint for us. You're wonderful. And okay, so thank you. I mean, if you care to sit and attend our SWRCB meeting, you're welcome. Otherwise, no, we are good to go. Okay,
Thank you so much for having me.
Thank you
very much.
It looks like Lisa raised her hand again.
Member Kirk?
I'm good.
Okay.
Okay, all
I'm
right.
good.
Oh, thank you, Ms. Floyd. All right.
Thank you. You have a good evening.
So the next item is item number 3 of the agenda, approval of minutes of meeting dated March 14, 2022. So the minutes was posted on the county website since last Friday, and I presume that everybody has read it. So if there any question from anybody, otherwise I would like to ask for a motion. No question. Okay. Now we have a public question from Ms. Esch.
Yes,
Yeah.
I have a question. I don't have your minutes right in front of me, but would you tell me who was on the roll call at the beginning of the meeting? Was Mr. Prassa included?
Yeah, isn't he?
Okay, because his board seat expired in December, so he should not be counted as being present at the beginning of the meeting as a director. Thank you.
Okay, if no other public question or comment, may I ask for a motion to approve the minutes dated March 14.
I make a motion
Thank
that we
you.
approve the minutes.
All right, thank you. Member Kirk, somebody second? Somebody second?
I second the motion.
I second. All right. So I take a roll call vote. All right. Mr. Prassa?
No.
No. All right. Mr. Walter?
Abstain.
Excuse me?
Abstain.
Abstain. And Member Wu?
Abstain, I wasn't here.
Okay. And Ms. Kirk, you made the motion, so I presume it's a yes vote.
Yes, yes.
Mr. Heath?
I also was not present for the meeting.
So, Ms. Quo, what's your vote? Ms. Quo? John?
Yes.
Do you approve the minute?
Yes.
Yes. Okay, so we have 3 yes, 2 abstain, and 1 no. So I guess that will pass our motion because we have 3 yes and only 1 no. Okay, so I declare the motion passed. So we move on to the next item, which is number 4, LMC correspondence. Okay, LMC correspondence, we have a lot of correspondence today, but I just want to read one. I just want to read one correspondence, which is from Mr. Chris Fowler and Kimberly Mancy, residents at 13911 River Road, Locke, California. Okay, it started with, while speaking with Douglas Hsia in March 2022, we made a request to be reimbursed for the cost of gravel for the common area driveway. We made the purchase 2 to 3 years ago. Because of muddy potholes in this area, we spread the gravel over the whole of the driveway. For that 2 to 3 year period, we got no services and leadership was very shaky, if present at all. Next paragraph. More recently, we had to hire someone to clean the leaves from the common driveway. We asked if we could be reimbursed for these things, and Douglas said he would bring it to the board. Next paragraph. We understand that other residents didn't agree in such cost, but it is personal. In this matter, Douglas Hsia was trying to make it fair, but instead got accused of nonsense from other residents or board members. Next paragraph. Let us be clear, at no time were we induced, coerced, bribed, or otherwise involved in any act of undue influence. Signed by Chris Fowler and Kimberly Mancy. Okay, so that is so much for the correspondence for MC. We have others coming up on the later agenda. All right, so now we're moving on to item number 5, Treasury reports. All right, so yeah, Mr. Prassa, can you take it away?
Yes, for the end of April, as of April 30th, we received $2,360 in total income. All of those were, about $10 were for the assessments and $10 for boat and trailer storage fees. We had $2,801 worth of total expenses, which netted us a $440 net loss on the month. And so on the next page, you'll see the balance sheet. And the page after that is our payables transactions for the month. It's all pretty self-explanatory.
All right. Any question from the board members?
So I have a question about the legal services. 1,280, I think it's 86 or 66. What did we need from legal?
That was to start a memorandum in order to collect the monies that were spent to collect the on our judgment that we received.
Okay, so so they received a check for, in the equity you've got 248,000 and then 326,000. So they received a payment from the Esch account, correct? Is that what that equity, the minus equity is? I'm not quite sure what what that equity, can you explain that equity column to me?
I'm not seeing what you're looking at.
Okay, on the balance sheet, it says equity, retained earnings, minus 248,000 and some cents, and then net income, 326,000. Was that the payoff?
Yes, that was what we paid to B.P.E. That was what we owed them. We received money on the sale of the house that came into B.P.E. and it paid off the balance that we owed them.
Okay, so the balance. So why is there another 1,266? What judgments are they going after?
The entire judgment that we got was somewhere around 390,000, 380. I don't have the exact numbers right in front of me, but
right.
The amount that came in from the sale of that house didn't pay what wasn't enough to satisfy the entire judgment. It was a little bit more than the amount that the L.M.C. owed B.P.E. So what happened was that amount paid off the balance that was owed to B.P.E. and the Locke Management Corp, there was about a $1,500, $1,600 difference that came into the L.M.C. at that point. So there's approximately $66,000 left owed to satisfy the judgment.
66,000. Okay, so is that the lawsuit judgment?
Yes.
Okay, and so you're saying that there's 66,000 more owed on the lawsuit judgment?
Yes.
Okay, and so why were the liens taken off of the Esch property?
I don't know that.
Okay, I'm going to recommend, because we need to get a clear understanding of this, that we have a closed session with B.P.E. law firm and figure out what exactly is owed, because total equity, I don't know. I don't see any column. Which column says that 66,000 is still owed to B.P.E.?
No, it's not on the balance sheet. It's not on the balance sheet. Let me see. I've got some rough numbers right here. The approximate judgment was about $396,000. We received about $329,000.
Okay.
All but $1,500, approximately $1,500 or $1,600 of that went directly to B.P.E. to pay off the balance. That left a balance of around $66,000 and change.
All right. So I don't want to get into legal stuff here, but so the check written for legal services, 1,266, that was to hire B.P.E. law firm to go after that additional 66,000?
No, it was to write a memorandum that's going to be added to the judgment for an additional $44,000.
All right. So, we still haven't really got a clear understanding of how much they were paid by us, how much was actually owed to them, and now I'm confused that there's still 66,000 left. That there should be a current judgment. If the liens have not been released, there should be a current judgment on the properties. That why are we paying B.P.E. law firm to go after him? So I'm going to recommend at the end that we have a closed session with B.P.E. law firm, and they can go over and what is their strategy. And also, I'm just going to throw this out there now. I would really like, since B.P.E. also does real estate, they might be able to help us out with some of this Davis Sterling stuff. So if any of this includes assessments, we want to make sure that we follow the Davis Sterling Act if we're going to go after people for their assessment. And maybe B.P.E. can give us some advice on making sure that we follow the Davis Sterling Act before we go after people with assessments not related to different lawsuit judgments. So that's my recommendation, because I don't see anywhere on here that we're owed $66,000 still in this lawsuit. That's my recommendation. But I'll do that at the end of it.
Okay, where can we see that there is still an outstanding of $66,000? Where can we see this amount of outstanding?
It's in a letter that accompanied the recap of all the charges that you asked for.
Okay, so you will present those. You will explain to us at the later item, right?
Certainly.
Okay. Other things that I noticed that our accounts receivable that is only has an increasing trend. That means that there are more and more delinquent assessment accumulating. So, what is your take for that? I mean, do you have any plan to reduce it? Because the accounts receivable make up 60%. The accounts receivable. Let me see. I wrote that. The accounts receivable make up 60% of our budget income. Okay, so a large amount of our money is locked in the accounts receivable, and those cash is not good until they become cash. So, what is your plan to reduce the accounts receivable, meaning to collect more assessments or delinquent assessments?
In the middle of preparing another round of letters to the people who are delinquent, but there's one problem with that. The last time I sent letters out, you and other members of the board criticized me for being abusive and overbearing. So which is it that you would like me to do? Send out letters of collection to people to ask them to pay, or would you like just simply let the accounts receivable build and build and build? I can't do both things. I can't send letters to people telling them that they need to pay us and then not be accused of being overbearing and abusive.
Thank you. My advice for you is send those letters without the bold letters. How about that?
It's the same letter that's been used for the past 10 years. It's the exact same letter. I haven't changed anything. It's a letter. It's a letter that's been approved by the attorneys.
Okay, send them out.
What? So would you like to rewrite the letter for me then?
Well, I would just tell you, don't use any more bold letters.
Well,
Okay?
how do I know that you're not going to like something else that I do? So why don't you rewrite the letter for me then?
No, it's your job. You treasurer, you go collect.
I was doing my job and I was told that was abusive. So
Good. Okay, you were accused of being abusive because you wrote bold letters. You used.
I didn't write a thing, Douglas. Those were the same letters that have been sent out for the last 10 years. The exact same letter.
Okay.
The only thing that changed on the letter was the name and the amount owed.
Okay. All right, we move on, and I move to adopt the Treasury report. All right, and then there's no motion necessary. And now we move on to item number. Okay, item.
Do you want to do public? Do you want to do public comment?
Okay.
Yeah, let's do public comment.
Public comment. Okay. Mr. Alexander.
Yeah, I see that we got delinquent payments of 60%, somewhere in that range, as I heard. Do you have the numbers on what they were before the board had the year of hiatus? Because I'm pretty sure they were down to about 5%.
Brock, do you have the agenda? Do you have the agenda package?
Yeah. Well, I did.
Okay, and I know it's really long. In there, there is the Locke Management 2020 bills paid, and when I went over it, he broke it down. Joseph broke it down into what was paid in 2020, and then what was occurred and paid in 2021. And I did some quick figuring. It looked like and about $12,000 was paid for the 2020 bills. And Joseph, correct me if I'm wrong. And he split it down into like SMUD, Lockwater, B.P.E law firm got $2,000 in 2020 and $28,000. I guess
Before the year off, which was, I believe it was 20, right? Is that correct?
right.
Before that, what was the numbers before the L.M.A. dissolved a little bit? What was the percentage of delinquent payments?
I don't know, but I could probably get the bookkeeper to generate that report.
Okay.
Well,
Because
maybe.
my point I'm going to make later on is that it was significantly different, and that leads to a later discussion. But 60% is really high. I mean, extremely high.
Well, from what he printed out, it looked like the expenses were about $12,000 for insurance, SMUD, and those services. It looks like the attorneys came in at almost $30,000, but I'm not quite sure. There was a credit in here of $13,000. So what I'm thinking is for 2020, since the lawsuit seems to have been paid, and that is the question, are you going to charge the homeowners for 2020 that $30,000 if the expenses just came to $12,000? And that's something you might want to think about, Brock, because, that's kind of where I've been going at, is there were basically no services. I understand that things had to be paid, but, would that require a further reduction for 2020? Those are my thoughts.
Sorry, I think we will touch upon that item under the new business, okay? Under the new business, item 7, discussion of Locke Management Corporation 2020 expenses. So we will touch upon that. Okay,
I'm sorry.
To answer Alexander's question, I can share screen with you. I have some data here. Okay, I don't have it in my share screen here, but I can tell you that 2019, December 31st, 2019, the receivable was $7,483. And the year 2020, December 31st, is $39,000. All right? So have I answered your question, Mr. Brock?
No, not my question.
Because you said, what were the accounts receivable like in the previous year?
I wanted to know the percentage of delinquent accounts because James was the treasurer and he did a great job of getting that number down. And what I want is a contrast from what James was doing to where we are now.
Okay, I understand. Yes. Okay, we will work on that. Okay, I'll make a note.
And James's hand, I think he's here.
Since I was the treasurer then, and thank you, Brock, very much for the acknowledgement, the collection of assessments is the lifeblood of the LMC. You have to go after delinquent people. I can't stress this enough. The reason that we were such an effective board and why this board is having such trouble with this is because they have not taken a strong position. Joe is trying to do the best that he can, and he's not getting the support from particularly you, Mr. Chairman. He needs your support to go forward with the collection of these delinquent assessments. If you deny this to happen in the legal way that it's necessary to happen, you are thwarting the lifeblood to make things happen here. So, there.
Thank you.
Nice.
Okay.
Nice saying.
Going back to our efforts, at the last meeting, I was able to get Mr. Chris Fowler to pay us. All right? And my effort was attacked by Mr. Prassa. And my approach, it worked without any legal letter, and the member, they paid. But then I was attacked. So my effort was neutralized and wasted by Mr. Prassa.
What?
There was nothing of the sort done. What I said was that you were trying to collect by making a deal with Chris Fowler to pay him a $400 and some bill that he says is owed to him by us. The deal that you made was, we'll pay you that if you start paying your assessments. That's what I said. And that's exactly what happened.
Well, I mean, if they well deserve it, then we reimburse them.
He doesn't have any evidence of it. He has no receipts. Who knows what he did?
You haven't asked for it. You haven't asked for it. Okay.
You were the one that made the deal. Where were you? I didn't make the deal with him. He hasn't approached me.
I will ask for it after the board approval. Okay, why would I want to ask for receipts before the board approval, right? So if the board approves, then we get the paperwork.
You want an approval to pay him before we had any receipts or anything. That's not the way it works. He brings the evidence that we owe him the money, and we'll pay him.
Subject to receipt of receipts. That was the motion. If you check the minute, that the motion is the subject to availability of receipts. Okay? All right. Mr. Motlow, you have your hand up.
Yeah, you keep going back to this thing with Chris Fowler. I think we're trying to justify that what you were called out on in the last meeting. But we did point out to you that the terms that you were trying to work out with Chris Fowler and you say bring to the board were in violation of our bylaws. The method of payment, the breakdown of it, and when they would be applied. So, and did you call Joe a racist?
Okay, this is not about the issue. All right. Now, first of all,
I called him a racist.
Okay, you're out of line. Point of order.
Oh, what? Is that all it takes? You cannot call somebody a racist. Shut me up.
Do you want to stick to the agenda or not?
Whoa.
Okay. Now.
Okay, I make them. Are we still? Excuse me. Are we still on the treasurer's report? We've had public comment. Is there any more public comment on it?
Yeah. And I need to answer Mr. Warholt's question. He said my motion was in violation of the bylaw. And please check the minute. The minute I said the motion is put all the payment into oldest arrears. Okay? So we are not splitting the payment. Check the minutes.
The minutes you created.
And check the recording. Check the recording.
Yeah.
Check the recording.
Keep your head, Douglas. Keep your head.
Okay.
So if there was an objection to the minutes, then it should have been specified, and we could have dealt with it, but we've moved on.
Yes, we move on.
Are there any more public comments?
Yes.
Who's running this meeting?
Yeah, who's are you the chairman now?
No, but I'm just trying to keep us on track because the time's out of it.
It's Douglas's job to run the meeting. Let him run.
It's okay. You know.
It's okay if she agrees with you.
He's being outnumbered, bullied. Okay, so she stepped forward. Thank you. Any more comments?
Yes.
Okay. Who?
Martha.
Ms. Esch. Okay, 2 minutes.
I would like to ask Mr. Prassa if he has scanned the 270-page document he was waving around at the last meeting yet, so that the public can read it and put it into the county's website so that we can see what it says.
Okay, Ms.
I have not scanned it. I know there was a request to scan.
I put in a public record request for it to be scanned 2-3 weeks ago.
All right.
Should have been done by now.
Ms. Esch, we can touch upon that subject at the later item. Is that all right?
Because it has to do with the Treasury report or whatever subject. Sure, whatever.
Okay, thank you. All right. So the Treasury report is adopted. Now we move on to item number 6, old business, fire alarm progress report. So last time you say, Mr. Prassa, you say we were talking to Verizon. So what's the result?
I have nothing new to report.
So you didn't do anything?
I have nothing new to report. Nothing different than last month.
Did you make any further contact with Verizon?
No, and I'm going to tell you that I no longer have any time to be able to deal with that, so I'm turning that project back over to you.
Okay, so you are no longer on this you are no longer on this task. All right, so you have given up on this task.
I have not given up on anything, Doug. I am simply saying that I don't have time to deal with the many jobs that I've been given to do around here. So
Right.
I'm turning this one back over to the board.
Okay, all right. So you know, we are all busy people. We all make our sacrifice to do our community service. And okay, so if you think that you are too busy, then fine. Okay, then we will find somebody else to do it. Okay, so next item. Report of transaction record with B.P.E. from the treasurer. Okay, the 270 pages. Okay, this is where the meat is. All right, please go ahead. Well, how's your report? I mean, last meeting you said you're going to study the 207 pages. Now, give us the results.
I don't understand what you're asking for here.
Because at the last meeting, you said you got 207 pages from B.P.E. and you were going to study it, analyze it, and report back to the board.
Yep. And the report is that the amounts that the awarded amounts to us was $396,000 and change. The amount that we owed B.P.E. was $329,900 and change, and we still owe. That's not. I'm talking. We have paid off B.P.E. to all those numbers. We have paid off B.P.E. in full with the $329,000 that we received.
We had that information at the last meeting. There's nothing new. So what have you done? Since March 14th.
It seems like those numbers are correct that we got from B.P.E.
Okay. So so this is a report from Member Prassa. So do I have any questions from the board?
Can you go over what item specifically we're on right now?
We are on number 6, old business, report of transaction records with B.P.E. from the treasurer.
Okay.
So we are talking about the 270 pages of report coming from the B.P.E. that our member Prassa spent time studying on.
Okay. So, member Prassa, so the you put in the Locke Management Corporation incurred expenses. There's 3 pages of that. Is that to show what BP law firm was paid, or was that just to show what was paid?
I don't know what you're talking about. The only thing that I've submitted to you is this month's treasurer's report. What is this other thing?
Okay, so I went and had the whole thing printed out because it was too hard to look at. In that report, it says page 1 of 2, 2 of 2, and 1 of 1. And on the top it says Locke Management Corporation accrued expenses as of December 31st, 2020.
Are you talking about this thing here? That was something that Douglas asked for. I don't know why he needed that, but he asked your questions ought to be for him on that. I don't know what you want.
Okay, because I was confused because it does show information, and I'm like, okay, so it shows specific information for 220.
Okay, I'm sorry. I thought you were referring to the Treasury's report this month. I apologize.
No, and this thing threw me off. So now I understand, that Douglas asked for this. Right. Thank you for that. Okay.
A lot of pages in this month's things. I'm sorry.
I know, and I wouldn't had it printed because I was like, I can't look at all this. So, all right. So, Douglas, did you have this printed for this item?
You mean not talking about the 270 pages, right?
Right. There's three pages, or was that for another item? Because it doesn't say which agenda item these 3 pages are for specifically.
Okay. I think those are in relation to what member Alexander, he was asking for the 2020 expenses. Is that what it is?
Gotcha.
Yeah.
Okay.
So
Okay. All right. Okay. So back to the B.P.E. law firm. So basically, what you're saying is there's $66,000 owed.
Lisa, if you wanted to go into an after sessions meeting with the directors, I'd be glad to expand on it for you, but I don't feel comfortable doing it now to the membership at large.
Okay, that's why we should go into closed session. That's okay. Then I think this item needs to be moved. That I would make a motion that we take this item and do a special meeting and a closed session. And you know, if there's any more pending litigation and there needs to be another action on that litigation, then we should probably all meet in a closed session with the attorney to figure this out. Because I'm not really comfortable talking about more pending litigation, but then the only other option we have is a closed session. So I would make a motion that we move this to a closed session in a special meeting.
So, okay, can you elaborate on closed session? Do you mean that presence of all board members with the lawyer? Or
Yes, I mean, okay, so under the Brown Act, when you do a closed session, it's regarding litigation. And since this is litigation and pending litigation to collect on it, I suggest that we go into a closed session, all members of the board, because that's how it's done under the Brown Act. There's no executive committees under the Brown Act. I know there is under the Davis-Sterling, but not under the Brown Act, with a meeting with B.P.E law firms so we can figure out exactly what this is. And if they're going to be... So I make a motion that we take this item, the pending balance on the litigation, and do a closed session with B.P.E law firm in a special meeting.
okay, let me see. Okay, let's go through the. Okay, I remember your motion. Okay, let's go to the other comments, and then we will move the motion. How about that?
Okay.
Let's hear out other questions from the board. Okay, so Mr. Water.
I'm not sure Joe really elaborated on, I think he's been crystal clear on 66,000
Right.
still owed, and the additional 1,500 or so that was paid to B.P.E law to create the memorandum for another approximately $40,000 that was accrued in collection since the judgment, since that final judgment that we've been acting on. So it's going to come to like a little over 100,000. I would like to add too that B.P.E law has made it clear several times in correspondence that they didn't want to deal with an entire board on this. This is why Daryl Wu, who's been on this for, I think, the entire 11-year litany of...
Stuart, that's not an option under the Brown Act.
Lisa, please quit interrupting, and would you mute yourself and put your hand up when you're going to talk? It's not going to...
This is a board member. You are addressing it directly to Lisa, so Lisa has the right to respond.
I am trying to clarify this to the board.
Okay.
So, B.P.E has asked that Joe, Daryl, and I work with them on this. We're not trying to keep things hidden every time, but you have to realize that I don't know what music is playing.
Eileen, please mute yourself. Eileen. Stuart, can you call Eileen to mute herself, please?
Hey, Douglas, if you are the meeting owner, you should be able to mute a participant.
Oh, yeah, you're right. Okay, let me. Oh.
Thank you.
Thank you, Eric. I forgot my power.
I think rather than try to reiterate everything I said, I'm just going to say I said what I said.
All right. Okay. This is my comment. Okay. I think maybe I would like to get a copy of the 207 pages due to the fact that Joe Prassa is so busy with his life, and I would like to take part in looking through the 207 pages. So can you make the 207 pages available for me?
Certainly.
For everyone.
I don't know who. Okay. All right. Okay. So when can you have it ready?
When can you be here?
Scan it onto the county's website, please.
Yep. Send it on the county website. All right. Can you do that?
I don't know. That's not something I'm familiar with, putting it on the county website. What would you like me to do?
Hand it to Florence Evans.
I'm not sure that's a great idea.
Okay.
This is-
Send to me, Kevin.
These are confidential documents for the LMC.
Okay.
It's a public agency.
Okay. All right. Send to me. They are in paper. They're in paper pages, right?
Yes.
They're not in soft copy. All right. So they are not in soft copy, right?
They're on
are-
pages, pieces of paper like this.
So if I come over tonight, you gotta give me the whole thing to me. That means you won't have it. So we need to make copies. Can you ask B.P.E to send me a soft copy?
Do you have any idea what they charge something like $30 a page for copies?
Oh my God.
Soft copy. Send it in the folder, in the PDF file.
They're going to charge us for it, but if that's what you wish me to
I
do,
mean,
sure.
as far as it's not $30 per page, I think we should be able to afford it. I mean, $30 a page, no way. But it is $30 for the whole thing. Yes. Go for it.
If that's what you want me to do, I'll do that, sure.
Please. Okay. All right. All right. So, Lisa, you have your hand up again.
Thank you. You can send the document to UPS and it's 30 cents a page, but you have paper pages. So I suggest that you just hand over that to Douglas and he can make copies and then maybe ask the county. I don't know about putting it on the website. We are a public agency, and we do come under certain regulations. So this is why I think we all need a closed session. I understand that certain people have been contacting the lawyers only, but in the groups that I'm in, we all, as board members, meet with the attorneys. And if we're looking at spending further money and litigation to collect this amount, we all need to be involved in it. So, but I think there's a cheaper way to if you just hand him the document and let him make copies. I think there's a certain way to do this. Would you be willing to hand him the physical copies, Joseph, so he can make copies?
Sure.
Okay.
Okay. First of all, ask B.P.E if they can send me a soft copy less than $30. If they can't, then I will come to your residence and pick up the physical copy. Is that okay? Is that fair? All right. So now I go to public comment. Ms. Esch.
Yes, I'd like to know.
Sorry. Mr. Heath, you have okay. Board member first. Sorry, Mr. Heath.
Okay, thank you. Just really quickly, these are. I'm new to the board since this litigation, so I don't know what's in these documents or in the billing statements. I would, however, note that to whatever extent there is attorney-client privilege applicable to the details in the line items, not necessarily the amount of time or the hourly amounts billed, but certainly to whatever extent there would be any indication of strategy or work product or anything like that, distributing that publicly would waive that privilege, which may not be something that the board or the LMC wants to do, particularly if it would be accessible to anyone or to an adverse party. I just would like to point that out. That is a consideration. And if if Joe is going to ask the law firm to send a soft copy to you, Douglas, he might also ask if there is, I guess, attorney-client privilege information in the billing line items that we should redact.
Okay, agreed. So first, send it to me in soft copy. If no, I will come pick up the physical copy. All right. So that's the understanding. All right. Okay. So going back to public comments and Ms. Esch.
Thank you, Mr. Hsia. Thank you, Mr. Walthall, for clarifying who has been communicating with the Locke Management Association for all these years. I've put in that public request a number of times. It's been completely ignored. I've often asked who is the legal advisory committee of the Locke Management Association and was met with stone silence. I did see Mr. Prassa's name on the title report, his signature back in December to accept $330,000 thereabouts that I paid. And I don't see it as an income item on the report that was supposed to be sent to all of us general members by April 30th. That hasn't happened either. There has not been a noticed, per Brown Act requirement, a noticed closed door session of the legal advisory committee when they've met or had communications with B.P.E. Law Group. There has not been a noticed meeting since July of 2012. And these are all Brown Act violations stacked up. Thank you.
Great. Mr. Motlow? Mr. Motlow?
Thank you, Chairman Shaw.
You're welcome.
Being the past treasurer and being very sensitive to the amount of money that we had to pay B.P.E., we were very hesitant to have unnecessary meetings with them. When you're proposing this meeting, a closed door meeting, which you can certainly have, the B.P.E. law firm does not do anything for free. They were going to charge you a tremendous amount of money. That it seems money is the key thing that keeps reoccurring here. Questions about how money was spent or not spent or effectiveness and so forth. So what you're looking at is a multi-$1,000 bill in order to have them be a participant in this meeting with you. If you want to incur that, fine, go ahead. But recognize that the law firm does things by the minute in charges for everything. So be very sensitive to when you are thinking about dealing and having anything mailed to you, anything asking for advice, you're being charged by the minute. That is my advice to you.
Okay, thank you. Member Kirk, you have your hand up again?
Yes. I know, but they also do charge when they're meeting with just a few of you. So as a board, in order to comply with the Brown Act, it is best that we all meet together, because whether there's two of you or the full board, it's still the same charge.
Thank you.
Thank you.
And Mr. Alexander?
Yeah, first off, just following this meeting is very difficult because it's done, I can't tell who's running it. Lisa's running it, then other people are jumping in, and then you take public comments, and then you go back to the board, and then back and forth. I hope county council is aware of this and watching this. There's some really good professionals on this board. I don't want to lose you. I want you to stay on this board, but it's a hot mess right now. is this the treasurer's report? B.P.E. Law Group item, correct?
Now, actually, I repeated a few times already. This is the report of transaction records with B.P.E. from the treasurer and the old business.
B.P.E. Law Group, right?
Yes. All right.
That's
so
just what I read.
This is about the fifth time I'm
Well,
telling the
maybe you
floor.
need to say it more because you're trying to take an action item. On my agenda does not say an action item. So Lisa put up an action item and now you're taking an action. I don't get it. So I think I'm in the wrong
We are
category.
not taking action.
Yeah, Lisa just put up an action. You said we got it. We'll go to the public first.
We go to public
You
first.
can't
Right? Please,
on
move
it.
on. Okay, Mr. Motlow.
You can't make an action on it. Move on. You got to follow the rules.
2 minutes up, Mr. Motlow.
Yeah, I realized
30 seconds left for Brock if he still wants it.
Okay. Okay. All right.
That's all right. I'll save for next. He's now the timer.
I realized Lisa's concern and maybe everybody's concern that's not only a L.M.C. director, but a member of the L.M.A. And I realized that all the legal machinations and decisions have been made by a smaller group than the entire L.M.C. board of directors. This is what B.P.E. has asked for. But I want to point out that we don't have a bad track record on this. In fact, we have a good track record. We've already collected the $330,000 from this whole mess. We're still owed $60,000. That's going to go to us, the property owners. And we're trying to get another $40,000. That's why that additional $1,500 bill. So I hope that, for instance, Lisa's motion to have a closed session and let everybody in on what's going on here isn't because she's dissatisfied with what we've been doing up to this point. I think we've done our job up to this point. So that's what I got to say.
I think that we are looking for more transparency for this situation. Okay, so I would like to see the 270 pages myself, and I like to see. I mean, personally, I would like to see where it shows $66,000. Okay. Yep. So transparency is what I'm looking for, and I think other board members are also expecting the transparency. So we expect to participate in a session with the B.P.E. law.
To what ends, Mr. Shaw?
Excuse me?
To what ends? Are you saying that we have not been are you saying we're doing something wrong? We haven't been transparent enough? I know you.
Well, I mean, I haven't seen anything, and I know that Mr. Prassa is so busy, and I mean, I just want to.
Douglas, I'm feeling threatened. You keep repeating that, and I'm feeling very threatened right now. Please don't threaten me anymore.
I don't threaten you.
I'm feeling threatened by you constantly repeating that.
Well, what happened to be scared? That's what you said. Okay, Ms. Kirk, what else do you have to say?
No, I just think that if we're going to spend more money to collect it, I'd just like to know how much more money it's going to cost to collect it. And yes, I think, as board members, we need to understand, how much more is owed, how much more it's going to take to collect it. And is there any negotiation in this? And, we're all one board. And I think that a closed session with B.P.E. would be beneficial. That's my, that's my statement, and that's what I'm looking for, just trying to understand this, And how much have we already paid B.P.E. with the $1,000 retainer every month for I don't know how many years? So that should be, I suppose, I don't know how we're going to figure that out. I mean, how much exactly was the lawsuit, how much have we paid them, and that $1,000 month retainer. And those are things we need to sit down as a board. If it takes a closed session to do it, then that's what we need to do. And hopefully we can do, I mean, it would be good if we had a working group, if we could do a working group together to look at all these figures. So that's my statement. Thank you.
I agree that I don't think the conversation with the B.P.E. should be the privilege, the only privilege between Prassa and Mr. Walter. I think the entire board.
You're leaving Daryl Wu out of this. Are you doing that on purpose, Douglas?
Well, I don't. He's not here to verify. Is Daryl here?
I think he left.
Okay.
Is he still in the discussion?
I don't see him.
Okay, so he's left the meeting.
He said he will leave at 7 o'clock, and now 7:55. Okay. Let's make it this way. Let me look through the 207 pages. Let's agendize this item at the next meeting. Okay. Whether we would like to insist on having a closed session with the B.P.E. Is that all right with you, Lisa?
That's fine with me.
Okay, so it's in the record, and we move on. The next item is nomination of property representatives election process, action item. So, who would like to, which member of the nomination committee would like to get up and speak?
I'm happy to speak.
Okay. Please.
I'm not exactly sure what the action item is. I mean, fundamentally, what has happened since the last meeting, and actually since 2 meetings ago, is the nomination committee, which is myself and Ginny and Joe, put together the nomination form to be sent to all of the property owners of Locke. I believe this was sent out by mail to every owner. I also understand there was an oversight where some people didn't get the form, but that has subsequently been rectified. And I understand that we have received some responses and that those are being held by the bookkeeper as a third party prior to reviewing them. Once we are able to open those and check who has been nominated for which seat, we will contact the nominees to see if they are willing to serve on the LMC. If they are willing to serve, and if there are more than one candidate for each role, we will have an election. That election will be held also via mail, similar to the nomination process. I believe there are third-party validation or verification requirements associated with that. So we'll need to figure out how we're going to handle that piece. But once we get all the envelopes back from the bookkeeper, we can move forward with contacting the nominees and then putting an election letter together and sending that out. I would say, Joe, if I've left anything out, please correct me. I don't know if Ginny's on this call. It doesn't look like she is, but
I am.
Okay. Hey,
Oh,
Ginny.
there you are. Okay. The ballots we had until Friday the 6th. That was our date, and I think and Ginny was going to go by there and pick them all up in one group. But I think that Andrea was sick that day, so you couldn't pick them up Friday, and you made arrangements to pick them up today. Is that correct?
Okay, yes, I picked them up today, and she said there were only 2. I haven't opened it, so I left that sealed.
So Ginny has all of the nominations that have come in so far.
So have you prepared a independent party to open those nominations?
We have not. I mean, I think the third party requirement is attached to the election itself as opposed to the nomination process.
Mm-hmm.
So I think we could open the envelopes and see who has been nominated so we could contact the nominees and make sure they're willing to serve. We could certainly do that. If others on the LMC disagree that the third-party verification only attaches to the election process, I'd be happy to discuss that.
Okay, my question is, we set May 6th, Friday, last postmark day. Okay, between May 6th and today, there's only over the weekend. So if there's anybody sending the nomination in from the Bay Area, I don't think it will arrive today. So what happens if we receive something tomorrow?
Well, I believe the letter gave the recipients 30 days to nominate. It's been well over 30 days. So even allowing for lag time for people sending mail from faraway places, whether the Bay Area or Arizona or wherever, I think we should have received them by now. I mean, I have no real issue with checking back with the bookkeeper at the end of this week to see if there are more nomination forms received. But I mean, I think we've met our obligations under the David Sterling Act.
So I think we should set a cutoff date. Okay, postmark is May 6th. All right. So presumably anything sent out with a postmark on May 6th in case it should not arrive later than say coming Wednesday. So should we set a date? Say okay, our cutoff day is Wednesday.
I think that should probably be put to a vote. I don't object to it, but I don't really have any authority to approve it or not.
Okay, all right. So that's one thing. And okay, so who's going to open it? Jeannie's going to open it and read to us. So is that how you plan to do it?
Well, if we're going to wait till Wednesday, it doesn't make sense to open anything now or read anything. The nomination, I mean, we can certainly open them after Wednesday and report who has been nominated. I'm sure it would be easy enough to document the envelopes and the forms via a photograph or a scan of the documents so everybody can see what was sent in. We obviously have Andrea, who is receiving these things. If we only have two that Ginny has, then there will be at least two. And if there's more than that, then they will come from Andrea. So we'll know, and we can open them and report out. In any event, what we need to do is contact the nominees, and then arguably, the nomination committee will have fulfilled its obligations at the time that the nominees are confirmed or not. So, and maybe there should be a separate election committee. That seems like, my thought is, if we're going to wait till Wednesday, fine. We should vote on that decision. If that is approved, we will wait till Wednesday, check with Andrea. If more letters or more nomination forms have been received, we will open them. We can document them and, I don't know, send them out to this group or whoever. We put them on the county website, whatever people think needs to be done. But in any event, we will do that. We'll contact the nominees for them to confirm their willingness to serve. And then we'll put them on a ballot, or the election committee or whoever will put them on a ballot and do the same thing again. And that's where the third party comes in.
So you are the lawyer. I come to you for your advice. Okay, if we open up today.
I'm not the lawyer of the Locke Management Corporation.
I know, but you're a legal professional. So if we open up today, Jeannie open it, read it, and if somebody challenges us, listen, I send it out, I put it in the mailbox on Friday, and then Andrea later on find out that, it arrived on Tuesday morning. So what can we do?
I just suggested that we wait till Wednesday. As you said, I confirm my agreement with your suggestion that we wait till Wednesday.
Yeah, but
and then we can. There is nothing in Davis Sterling that says that the nomination forms have to be opened publicly at a meeting. I mean, the nomination committee can surely do that, and we can report back what was with the nominations that were received.
Okay. So may I suggest that? Can Jeannie and Andrea open? Okay, we open it at Andrea's office. Me, Andrea, and Jeannie. So that will fill up the third party, part of the third party requirement. Do we do that on Wednesday? Okay.
That's probably a question for Ginny. I cannot be there on Wednesday.
May I
You can-
speak?
Yep.
Okay, I'm sorry, I don't have a hand up button. I would be happy to meet whomever on Wednesday. I can get a hold of Andrea tomorrow and see if she's available on Wednesday. She's not always there.
Okay. So should we move a motion? Okay. I'm gonna listen to other comments first, then we come back. Okay? Yeah, Mr. Wattle.
Yeah, first I'd like to thank the nomination committee for doing this. I would like to know, to help expedite the election process, because, you know, it's taken quite a long time. Who will be the election committee?
Joe, Eric, and
No, they're the nomination committee, Douglas.
okay, election committee. All right. When do we need the election committee?
I assume once those letters are open, you will proceed to an election.
So are you suggesting we should have different people from the original nomination committee?
Well, no, I'm just asking who would be the election committee.
Okay.
Eric, what do you think?
My take is it can be the same committee. I would prefer there to be a request that the nomination committee extend its service to include the election. If we want to do that, that's fine. I don't know if Ginny or Joe want to serve on it. I'm willing to give it a shot. Yeah, so that's what I would say. I don't know if that answers your question, Stuart.
It does. That's pretty simple. Thank you.
This is Ginny again. May I speak? I don't have a hand. I'm sorry.
Okay, Lisa has to speak first. She's brought
Sure,
member.
no problem.
Eric, can you tell me more about the third-party inspectors? What is that going to involve?
I don't know what it involves, to be honest.
Okay, I think we need to find out.
Well, it's stated in the Davis-Sterling Act. That's about as much as I know. I think what we should probably do is contact the county to see if they could suggest how this is done in other cases.
Well, see, the county doesn't oversee the Davis-Sterling Act. This is where we get into issues.
Oh, okay.
And this is where, this is the problem with the Davis-Sterling Act. Even B.P.E law firm might have an answer to this, or anybody that does property management of an HOA. And I've been thinking about this. I can try to find, if you want me to, I can try to find the answer to this question, because I've been curious of who is the third party inspector.
Yeah, I mean, Lisa, I would welcome any perspective that you might have from somebody who's done this before.
Okay. I haven't done it before, but I know the county, when it comes to the Davis-Sterling Act, we come under the Brown Act and there's some oversight there, but with the Davis-Sterling, we're on our own.
Okay.
So, all right, I'll see if I can find out what a third-party election or inspection is. Okay.
But don't you think that Andrea can serve as a third party?
I don't know how the Davis-Sterling Act interprets this, but we'll find out.
So are we going to hold everything until you find out?
Well, no, I'll start making phone calls tomorrow and trying to figure out what exactly that entails.
Yeah, but then we cannot.
Douglas, I think we should consider. We need to balance the interest in doing it properly so that it has the integrity intended under the regulations and the statute, versus the need to, or the desire to have it done sooner rather than later. Mm-hmm. I fully appreciate what you're saying. We need to get going, and I agree with you. We do, but I also don't want to let I don't want to do something that would then be vulnerable to challenge if there was a problem. If we don't check with, at least do some diligence about what would be required under a third-party election inspector requirement.
And now, observing the Brown Act, I'm not sure that if a few of us go to Andrea's office, open the nomination form, I am not sure if that is in compliance with the Brown Act neither.
I don't know about how the Brown Act would apply to the nomination process, but I would suggest as I mentioned earlier, the third-party inspection relates to the election as opposed to the nomination.
The county elections are totally different. This doesn't have anything to do with a county election. So the Brown Act only, because we come under the Brown Act because we're part public entity, but these elections are not part of the county Brown Act system at all.
Yes.
Just to verify that. Okay.
But I just want to watch our staff that, if a few of us go to Andre's office, open the nomination, and then we talk to some of us, say, this is what happened. We might have violated the Brown Act without knowing.
My understanding of the Brown Act is it relates to decision making. If all you're doing is if all you're doing is, I beg your pardon?
I think communication too.
Communication relating to a decision, certainly. But if all you're doing is opening envelopes with nomination forms, and with a third party, Andrea, who could be there, I don't know. She gets paid by L.M.C, so maybe that creates its own issues. But fundamentally, it's just reading who's been nominated.
Okay.
Right.
We need
That's
the names of the people.
election.
We need the names of the people so that we can ask them if they want to serve on this board, so that they can be elected. There's not much. There's not much decision making there. It's all pretty required by the rules.
All right. So let's go to public comment, Ms. Esch.
Yes, Mr. Heath, you mentioned that not everyone received the nomination forms until a later time. On what date were the additional forms to those people who didn't receive them? On what date were those postmarked, the forms that were sent to them at a later date?
I don't know the answer to that question, but Joe or Ginny do. I think Joe or Ginny, do you know when the follow up?
Yeah, I think it was about a week, and there were two people that were left off of the mailing list. I contacted, when I realized that those two people were left off the list, I contacted both of them and sent them each electronic files, and they both acknowledged that they received the material.
On what date was that?
I don't know the exact date. It was approximately a week after they were sent.
Because you need to start the timeline when everyone was notified under Davis-Sterling Act. And I would like to also, Mr. Hsia, I would like to make 3 more floor nominations to add to my 9 nominations that I sent to you. I'd like to nominate Sandy Black, Sandy Derringer, and Maria Sanchez.
Okay. Your nomination, that you understand that our understanding is you cannot nominate because you have a delinquent assessment. So unless you can prove otherwise, this is our understanding. So your nomination may be void.
Tell me what code section that is.
I believe voting eligibility is covered by the either Davis Sterling or CCRs. I think it might be the CCRs.
Well, state law, Davis-Sterling Act requirement, I cited in my nomination, and I nominated myself as well. I cited the code sections that apply to why I do qualify, even if I have not paid my assessment. I put that in my written letter that I sent you certified on April 25th. And I also sent it by email, and I sent it to each of the Board of Supervisors. So it's all in there. And if you haven't looked it up by now, it's very easy. If you look at the attachment, should be at the bottom, one of the last attachments on your packet. I qualify because you guys never offered me internal dispute resolution or ADR either. You've never offered it to me. So that allows me to qualify for board candidacy.
All right. So, Mr. Heath, we rely on you.
I'm sorry, I don't have that assertion or whatever backup materials in front of me to review, and I would be remiss to do so at this point because I wouldn't want to, interpret things on the fly. I don't know what requirement for alternative dispute resolution, or I think you said internal dispute resolution. I'm not exactly sure if any of those are legitimately required to be offered, and if the failure to offer such things actually preserves a property owner's ability to nominate in the absence of being current on their assessments. So
It's a
I can't say.
subsection. It's a subsection of 5105, Civil Code Section 5105, and it's about halfway down the page.
Is this being timed?
Just real quick. This is a fairly long section. Like I said, I'm unwilling to read it on the fly and issue any kind of interpretive anything here. But I'm not going to say I agree with you. So
how can we take a vote on whether, okay, does the board have the authority to pass a vote whether we will accept Ms. Esch's nomination of a representative? Does the board have that power?
I don't know. I did just see that, and it does say indeed internal dispute resolution. I'm curious if this dispute resolution might have been waived via the litigation actions that were undertaken against the LMC. So this is actually a fairly complicated question. But I'm sorry, Douglas, I don't know the answer to the question you asked either.
Okay. Well, okay. I don't think. Do we have any resources to answer Ms. Esch's questions? Do we have any resources? Is B.P.E ready to do it? Can B.P.E do it?
Thanks, Martha.
You're welcome, Jenny.
And B.P.E, I'm asking to Joe Prassa. Okay, you have obviously been talking to B.P.E. So does the B.P.E have the resources to answer that question? And how much is it going to cost us?
Do they have the ability as a law firm to answer that question?
Oh no, sorry. That's okay. Not in that wording. Will they do it for us?
I imagine they'll do anything as long as we pay the bill. Sure.
So
I think the last notice that I saw from them, their hourly rate is about $4.65, something like that. So if it takes them 2 hours, 3 hours to research something like this, which is probably not out of the question, we could be looking at a $1,200 to $1,500 bill to answer that question. So if you think that's worth it, then it's up to you.
So I think as a chairman, I would say I will let Mr. Boha speak soon. Just let me finish this one. Okay, I will say that why don't we, the board, make a decision whether we will accept nomination from Ms. Esch. Okay, and before that, I will ask Mr. Warhol to speak. He has something to say.
Well, as I understand it, Ms. Esch didn't use this nomination form that was sent out. If she used it via email or sending it to the county, then why didn't everybody else, any other Locke Management Corporation member, do the same thing? Just send in whomever you want, regardless of the eligible nomination list. Why are we making an exception for this?
Okay, so if you're gonna take it to the board decision, we can decide. Board member can decide on that issue. Okay, Ms. Kirk, quick. Okay, I think we are running out of time, so quickly.
There are other attorneys that deal with HOAs. I know one. I can ask what it would cost to review the questions that we have, if you want me to. If you want me to ask another attorney that deals with HOAs, I can get a cost.
Okay, Mr. Waddle? Mr. Waddle?
Yeah?
You have your hand up.
Oh, I'm sorry.
Okay.
But let me reiterate, Ms. Esch, the way she's doing this is not protocol.
All right.
Okay. So how about I make a motion? Okay, the motion is to accept Ms. Esch's nomination of representatives of the property and commercial property owners, even though despite she is delinquent assessment payer, and she doesn't use the proper nomination form. All right? That's the motion. And anybody second? No second? All right, no second, that means no motion. All right? So, motion lost. Okay. Now, going back. So, envision that on Wednesday, who is going to Andreas? Okay, the nomination form is with Jeannie now. So Jeannie is going to take those nomination forms unopened, back to Andreas' office. Who are going to be there at Andreas' office?
I am fine with Ginny and Andrea opening them. I don't see any, I see nothing wrong with the integrity of either of those. I don't think I think they're both perfectly capable of opening them and giving us a true report of what's in the envelopes.
Okay, all right. Do we need a motion for that? Okay, so
I don't think we need a motion. I think I agree, but I don't think it was. Do we have an action under this agenda item?
Well, the whole thing is an action item. All right. Okay. So I gotta repeat that. Okay. Jeannie and Andrea are going to open the nomination letter at Andrea's office, and then she will email to all the members. Jeannie will email to the entire board of the result of the nomination, and that does not require a board decision.
Douglas, I think what has to happen first, I think that those names should come back to the committee, and then we need to, as Eric mentioned a couple of times now, that we need to verify those names.
Okay. Right. The names will go back to committee. The committee will receive verification and acceptance of the nominees. Right? Okay, that's good.
Yes, and then once we've done that, we could report back to everybody.
All right.
We still have a job to do yet. We still have some work to do.
All right. Okay. Okay. Ms. Esch.
Thank you. I've got a couple more questions. Us folks who own combination zoned properties, commercial/residential combination zone, are we allowed to vote for and nominate people to residential seats as well as commercial seats, or are we being restricted to only one type of zoning? That's one question. And my second question is, well, it's not a question, it's a comment. The forms that you send out were deficient under the requirements of nomination forms. If you read the Davis-Sterling Act for nominations, there's got to be a lot more added to the notification to the general membership.
Could you be more specific about the deficiencies, please?
Just read the code section, put in Google search.
We did read the code section. We did read the code section.
No, point of order. She already had 5 minutes. Now you're giving another 2 minutes. What's
Fair
going
enough.
on here?
Common interest development nominations. That's all you have to put in Google search. There it is.
Okay. All right. So I see there are still questions, but I would like to move on. Okay. We have spent enough time on this topic, and I think we
I'd
have.
like a clarification, please.
Okay. All right, please.
And Lisa, would you please mute your phone? Just to clarify, if we, when the nomination... Lisa, would you mute your phone, please?
I just muted her. I muted her.
Thank you. If, when the nomination forms are opened and the nomination committee gets a hold of the qualified nominees who have been placed on the ballot that was provided by the nomination committee, if no one accepts a nomination, we will not have an election. That's correct?
That is
Yeah.
correct, my understanding, Stuart.
Thank you.
I would also note that the Davis Sterling Act provides that if there's only one nominee per seat, that those nominees can be placed without election.
Unopposed.
That's correct.
Thank you.
All right. Okay, so we move on. Thank you very much. The next item is under the old business, number 6, report of street lights repair and refitting. So we have Tony. Tony, are you? Yeah. So Tony, can you start your report? I know they have done very many good things for us.
Okay, yes, I been in touch with someone at SMUD, and as it stands right now, we requested a certain color light and certain lumens, the lowest lumens possible. And I think the only thing that I really have to report is that we asked that they just put one light up so we can see what it looked like before they ordered, I think it was 64 lights. They have to order enough lights for the whole town, and then they have to order backups for those lights. So they have to order double. But before, I said, please do not order 64 lights until we see what one looks like. And so that's about it. And it's just a slow process. They request it's a special light. They don't have in stock, so it has to go through their engineering department, and then they order it. It could take months, but it's moving along.
Okay. So sorry, the 64 lights, but there are different types of illumination for the 64 lights. So you need to test a few of them, isn't it? I mean, aren't there supposed to be like 3 kind of brightness?
We talked about that. There's certain lights that it's a good idea to have the higher wattage, but for the back areas, we're requesting not so bright.
Yeah, but you were talking about testing them, so you need to test different kinds.
Yeah, we want to see what it looks like. We want to see what the color of the light looks like, and we want to see how bright they are in the back of town.
Yeah, and then maybe you can invite a stakeholder to look at the samples.
Hey, and we can have a party.
Yeah. Yeah.
All right.
Typo party. Yeah. Thank you.
A lumen party. Okay. All right.
All right. Thank you, Tony. All right.
You're welcome.
All right. So we finish all business. So we will move on to number 7, new business. Okay. So a letter jointly signed by 7 residents of Locke, expressing their fear for their neighbors in the back of Locke. Okay, I want to make a note that Catherine of Locke Garden, she informed me that she would like to withdraw her signature after Member Walthall and James Motlow talked to her. So we let it be. And so I trust that Joyce have a comment to make, and maybe she has something to say. So Joyce?
Yes, can you hear me now?
Yeah, okay.
Okay, so this is what I am very concerned, but right now what I needed to do is just only very simple and say how I feel when I move in the Locke. So let me read the letter to the board members. Dear board members of LMC, the LMC board meeting on March 14 was horrifying. The tone and the manners is menacing. I was scared, and I have never been in a situation like this before. The previous board had a reputation of menace. The present board certainly is successfully carrying on this tradition of menace. I am 78 years old. I bought the property believing this is a sanctuary for Chinese so that I can work quietly with my art. But as a property owner, I was intimidated by criticism about how I parked my car, too much to the left, too much to the right, in the designated parking lot. Yet, every day I have to face the car consistently parked illegally, blocking half of the Levy Street entrance. Sometimes another car was added to the blockage of my studio entrance. Nobody from LMC has said anything. Now I try to come to town early so that I can find a spot on the main street just to avoid any further harassment. I spend my own money to reinforce the levy. I was questioned what I was going to do with it, as if I was intending it for illegal use. When LMC finally came to cut the tree limb on the common area adjacent to my property, I asked Member Prassa if they can trim the limb a little bit more so that the remaining stump would not block my stairwell. It was not incur any more cost. The answer was an intimidating say no. There was no room for me to say anything. When LMC decided how to cut the tree, I was never consulted. Why was I left out of the process? Why you never respected my rights, my convenience? On the fine Sunday afternoon, a neighbor knocked on my door, telling me I had hit her friend's car. I did not remember I hitting anyone's car. I was brought to the parking lot and saw there was a paint on a car front fender that looks like my paint, but I'm not so sure. There was no dent. I apologize to clean off the paint. To see if it could remedy, I offered to report to my insurance company. She made it difficult by not accepting any of my offer. We Chinese people are known to be non-confrontational. When people demand us to do something, we would do it to avoid confrontation. I was ready to do anything to resolve the situation. It was a minor incident, being blown out of proportion. I felt that they just take the opportunity to shame my poor driving skill. It made me nervous. Nervous I was for a few days. I called up my husband, my daughters, to seek advice. I felt bullied. Also, recently, I was asked to pay $120 per month instead of $60. that I have been paying according the invoice amount. Immediately I complied, even though it should be understood that the 60 was grandfather's in. Again, I avoid confrontation. I immediately complied. Just because we are ready to take whatever that is thrown at us, it does not mean we are oblivious to be intimidations that are thrown at us. Locke is proclaimed as a national historical landmark because the federal government recognized the legacy of Chinese here. It was a sanctuary for Chinese here. Please don't put us to live in fear here. I am scared. Even walk scared. And Ning Ho told me he is scared too. All the Chinese in Locke are just keeping our head down. Some of Mexican neighbors are doing the same, keeping their head down. I am now thinking to move out of Locke. I therefore gather enough courage to speak out. Please, no more intimidation. Chinese are peaceful people. Let us enjoy a little bit legacy of the Locke without fear. Thank you. This is what I feel when I live in the Locke for these few days. I am feel very uncomfortable, and I am feel very being bullied for some peoples. Okay, so thank you so much for listening to my report. Thank you.
I mean, I can understand exactly how you feel. I was petrified at the last March 14th meeting. I got sympathy from the county the next day. I happened to see Donald Tolley, and he showed sympathy to me. Because of the encouragement from the county, I am able to sit here to chair a meeting again. I was horrified, and I share the feeling with all the 6 signatories. Okay, Catherine, after she talked to James Motlow and Stewart, okay, she withdrew, fine with her, okay, but the feeling we feel are real. There's a letter coming from Alfredo Montalvo, and it is basically about the same thing. So what I'm trying to say is the people here, they may not mean to be, maybe they don't mean to be intimidating, but they have to understand that they can ignite fear. They can generate fear out of people when they act a certain way, even though they don't mean to be intimidating. Okay, so that's my take, and I go to Ms. Kirk for board members' opinion.
You know, we are a diverse, small community, and I think all of us have had a feeling of being afraid at some times. I don't think it's based on any kind of race. I mean, today I was in town and I saw a woman who was Chinese that had taught at the school, and then Robin King, who had lived in one of the buildings there. So, you know, we are a place that people come back, and there's still that feeling of they were there, they were a part of it. And what we're all trying to do on the board and in the community is maintain that for the public. But we do all have to live and get along with each other, and that sometimes can be difficult to do in Locke. But, you know, and I appreciate all the homeowners that pay for the whole town to basically be open to the public. But, you know, I do get a sense that sometimes there has been a sense that people needed to be controlled in Locke. And I've been up there 17 years. And this board, what we're set to do is to maintain those common areas so people can still come and enjoy the town. And, you know, I would just ask people to think about before you go and get involved in something, really to think is that your position to get involved in as far as like a personal car incident. And, you know, if you find that you're being afraid of people, I read an article on bullying, and it said just remove yourself from that person and please ask that person not to approach you. So that's the only advice I can give. But I think we all love this town. We all want to see it get better. It has gotten better despite our differences. But, you know, it is trying to be kind to each other and not think that we're all in control of one another.
Okay, Mr. Motlow?
Yeah, and I concur with what Lisa says. In fact, being chairman of the Locke Foundation, it's really our, not only to educate the public about the history of Locke, but also to celebrate it. One thing I don't want to see happen here, especially with lifelong residents of Locke, is to completely discount the deep, loving relationships. I'm going to count myself in there too, because I've been in Locke for 40 years, and I've had deep, loving relationships with the Chinese community, with the individuals in the Chinese community. Particularly Connie King, I thought of her as my mom. This racial issue that has come up, I know Douglas has been working closely with Joy. In fact, Douglas, I know for a fact that you were there collecting signatures for Joy's letter. You were fomenting this thing yourself. And you approached Alfredo Montalvo and talked him into writing that letter too, which hopefully we're going to get to it because it's absolutely slanderous. But let's stay on topic here with Joy. I am sorry Joy feels this way. She had made a couple of statements here that I'm a little confused on. She says that the LMC gave her no option on how to get that tree cut, and even during meetings, and I know a lot beforehand, was discussed on what Joy wanted done with that tree. To have her say that she was harassed and had no choice about the tree cutting kind of bewilders me a little. As far as the car incident goes, I was I was around at the time, but maybe Joe Prassa or Deborah can, because they were there. Regarding her being bullied because of that car situation, I'd like them to clarify that. So, but this whole racial issue is getting out of control. And I know, Douglas, you have mentioned to other people too, that you could take it farther with publications and whatnot. Not only does this throw people under the bus that are residents and even directors on this board, but it casts a pall on the entire town. So, Douglas, you have a big hand in what's going on here. And I wouldn't be surprised if you wrote that letter for Joy. You may have sat down with her, but you've been walking around with Joy, getting all those signatures. I have no idea how you got Yvonne's signature. You may have even driven to her house. Who knows? And then for you to follow up with a conciliatory letter to Joy telling her how sorry you feel in response to the letter that you had a hell of a lot to do with writing, I find rather ironic, kind of underhanded. So that's what I got to say.
Can I say something? Can I say something?
Yeah, okay, Joy, please.
Okay, so I just realized that I only say to the board how I feel. This 4 years I am staying in this town, how I feel. And no matter who and how to explain, and I just tell what I feel. Okay, so no matter how anybody to explain anything, but cannot change how I feel. Is that right?
Well, I
Did I
understand
say
what
that?
Joy, I
I'm
understand.
sorry.
I assume this is a conversation between Joy and I. I understand what you're saying, and I certainly don't want you to feel intimidated and frightened by living in town and trying to conduct your business. My point here was how much Director Shaw has been involved in fomenting this thing, and I'm being specific as far as those signatures go. To clarify some of the other issues regarding the tree and the car, which, obviously you brought up because they're very important to you and you feel like you've been harassed. I'm not in a position to do that. Joe Prassa was there regarding the trees and the car, and Deborah Mendel was there. I'm going to let them speak. So that's what I got to say. And I hear what you're saying. You're expressing your feelings.
Thank you. Well, may I express my feeling too? In November last year, I was working with Joe Prassa, Sue Wilson, and I felt I was totally bullied because of my race. I sent out a graphic image of Danny Chan, who was a Chinese American who served the country in Afghanistan. Because of all the bullying from his fellow soldiers, he killed himself in Afghanistan at the camp. Okay? I sent that message before anything happened, before anything went out to the public. I sent that message to Stewart, Sue Wilson, and Joe, and I was ignored. How I feel is real. Okay? Joe, when I invite him to my house for dinner, he will boss me over when to have dinner. Hey, I'm the host. He said, no, the dinner will come sooner. Praise Jesus Christ. Okay? This is how I feel, and I can say what I feel, and if I have contact with other people, and that's okay, because I can talk to people who share the same feeling, same fear with me. Am I allowed to do that? Am I allowed to contact other people who share the same feeling with me?
Are you asking me, Douglas?
Well, if you respond, yeah.
Well, your feeling is you're saying you're calling Joe a racist, me a racist,
Well, I sent a message to you. It was clear. I mean, you did not resolve it.
Douglas, it appears that if somebody disagrees with you, you're going to call him a racist. And I can tell you this right now, Joe is not a racist and Sue Wilson is not a racist. You're just throwing that out there to wreck their reputations. They are
I
not
can say how
racist.
I feel. Okay, we go to other board members' comment. Ms. Kirk.
Ms. Kirk already spoke on this.
Okay. All right. So, Ms. Esch.
Well, are the directors done?
Yeah.
I think Deborah's had her hand up for quite some time.
Okay. So, Ms. Mendel.
Yes, can you hear me?
Yeah.
Okay. First of all, I'll point out to anyone that I did send emails and they are in the packet. And it's pretty clear my response to this whole matter that regards Joy's issue about me pointing out that she hit my tenant's vehicle. And Joe was there. He saw the damage to the back rear bumper, not the front, and also the scraping of the paint off of Chloe's front bumper. So I will admit that I didn't see it happen, but Ms. Chloe is the only vehicle that ever parks next to my tenant's vehicle. And my tenants away, and I was responsible for it. I would like Joy to explain how it is that I was demanding anything of her. She was demanding of me that I allow her husband or another resident in town to fix the car, in spite of the fact that I told her very clearly it was not my car to make the decision, and the person was away because their mother had died, and I just asked her to wait. And I was very kind to her, and I didn't make a big deal out of it. I just asked her to wait. So I don't know how I was making it difficult for her by not giving her permission to do what she wanted. And it just baffles me. But I really made it clear, and I'm sorry that she felt bullied by me. If anything, I felt like she was pushing me to let her do something to a car that wasn't mine. And I asked her politely in multiple emails, please wait. And that's all I did. Now, with regard to Mr. Montalvo's letter, why is that letter in this meeting packet? And I've addressed that in my emails. It's beyond comprehension. This is just a letter from someone who's personally angry at me. It wasn't even addressed to the board. It wasn't addressed to the association. It's just a slam letter. It's defamation and it's libel. And I consider Director Shaw, a participant of me in the meeting packet. Alfredo's just simply was personally attacking me for reasons best known to him. I want to point out something, and I might as well use this platform to defend myself. Alfredo lives in this community because I referred him to Tony Rigona. I said, why don't you rent to Alfredo? He'd be a good neighbor. And he did, upon my recommendation, and Russell Ohms's. And I also want to point out, Alfredo, when he went away to Mexico, all right, I took care of his cats and his dog for weeks. Okay, so he's got a personal problem with the two of us. There is no harassment of Mexicans or lower income people here. The other thing I want to point out is that also, in addition, he mentions some kind of harassment in his wood shops. The reason Alfredo has had his last two wood shops is because Russell and I recommended him to those two landlords, and we secured for him 2 other places where he could run his business. So we have done nothing but help this gentleman. And for reasons best known to him, he is libeling us, defaming us, and this letter was not even addressed to the board of directors. And it's outrageous that Douglas Shaw would even put this in the packet. And I consider him a participant in this defamation. Now, Russell Ohms is with me. I don't know if he has anything to say, but I also want to point out, if we're going to air racial discrimination, laundry, all of this stuff, let me tell you that when Russell and I moved into this town, no Mexicans were allowed to garden. There was one family that was in the shade outside the community garden under the trees. And Russell and many other community members all participated in restoring the community gardens. And now, because of our invitation, when we were board directors, there are at least 2 families now that are of Mexican descent that are finally able to garden. And one of them has the most beautiful gardens in the whole area. So, yeah, I don't give a you-know-what about my time. This is outrageous that this letter from Mr. Montalvo has been introduced to the public at all. It's totally inappropriate. And what's going on here with this board is just off the charts. Would you please give the floor to Russell Ohms?
I really don't know where to begin. I guess I first responded to Douglas's accusation that we were so-called colonizers of Locke years ago. I believe you were 10 years old when I moved into town. Douglas. There's only one person in town now who's still here from that period. And I don't know where you got the story, that false narrative about who we were in those years. James and I talking about. I had wonderful relationships with everyone in town. You didn't know Grover Lee or Norman Lee. Those were Anthony Lee's brothers. And he was in high school himself. Clarence Chu wasn't here. Dustin Marr was in college. Did you know Kid Hart? Did you know So Young? Everett Leon? Did you know Connie King? Tommy King? Did you know Hoy Key? Did you know Sin's son, Carol Hall? Did you know Buck? Did you know Mrs. Chan? Did you know his 3 daughters? Did you know Sylvia, Wayne, Connie Chan? Did you know Mrs. Alyak? Did you know Way Hall, Ada Hall, George, Leslie? Did you know these people? Joe Chow, Bob Jang, Licky Chan, Ping Lee. I had relationships with all of them. I knew all of those people. There was never a problem. It was never a mind. Why would I even live here? But if you want to instill fear, if you want to really frighten and bully someone, call them racist. That right now, in this period of time, that is the filthiest, dirtiest, underhanded thing you can call anybody without any basis. And actually, both of us being Rotarians, we live by the creed, the 4 creeds. Is it true? Is it fair to all concerned? Does it promote goodwill and friendship? Is it beneficial to all concerned? Does it? And those are the 4 truths that you and I live by in Rotary. And to have you do this to this town, to conjure these beliefs up and use this forum, this Zoom meeting, to propagate those kinds of beliefs, I just believe you should resign. I'll be very blunt. I was so happy when you became chairman. I said, this is great. You're the chairman. This is wonderful. A Chinese chairman in a Chinese town. I was happy. I was happy. There's no time limit. There's no time limit. So
There's no time limit.
that's
You're
what I believe.
a public member.
So that's what I'm saying. I believe it's a total false narrative. You made it up. You
Cut the bully off.
Okay,
Hey,
Mr. Motlow.
you let
I mean,
you
yeah, very much Mr. Motlow?
Thank you, Douglas Shaw. Could you please mute Lisa, Kirk, and Miss Esch? They are very disturbing. Let one person talk. Please have authority here. You mentioned at the very beginning of this how I went to Catherine. You are wrong. Catherine came to me. She was highly distraught at your letter, at the signature that you pressed upon her to sign. She was highly distraught about that. She was in tears about that. She felt offended by your demanding that she joins us. She's never seen us. She brought up the thing of, we are not racist here. She believes me. We are very dear to one another. And by manipulating her, you manipulated her for your own evil actions. And I hold you totally accountable for this.
Mr. Prassa?
Yes, I'd like to comment on some, but I can't hear because there's something constantly going on in the background there. I'd like to comment on the interaction between Deborah and Joy. I came into the middle of that. And I have to say that Joy was upset. And I think that was obvious, but it was upset over the fact that she thought that she had caused damage to somebody else's property. That's what she kept talking about. And I'll tell you, there was no bullying on Deborah's part. In fact, Deborah did quite the opposite of trying to calm Joy in her being upset. If you realize that you hit somebody else's car, I'd be upset. You'd be upset. Anybody would, because we don't go out in the morning to try to damage other people's property. And when that became apparent to her, she was upset. So, but Deborah was in no way a bully, and she tried to calm her. And the fact, we both looked at the damage there and said, this is mostly paint, and it might be able to be buffed out at some point after Kim takes a look at it and makes a decision. No one was pushing anybody to get anything fixed. Nobody was pushing anything to call. In fact, Joy kept talking about calling insurance, and Deborah is absolutely correct. She said, don't do anything now. Let's just wait until Kim comes back and we might be able to fix this thing here without a lot of expense to anyone involved. That's what happened while I was there. No one demeaned Joy. No one tried to make fun of her. No one said that she was a bad driver. That is as far from what happened as could be.
Okay. Are you done?
Yes.
Okay. Okay, number one, I want to say that I never accuse you guys being racist. I'm saying we are feeling the racism. Doesn't mean that I'm accusing you of being racist. Okay? So now, do you guys think that you are so powerful now? You can dictate how we feel? Can you? I mean, I get a feeling that you are trying to educate me that how I should feel. We are sharing our feeling with you, hoping that you guys just watch how you carry yourself, because we are not outspoken people and we get scared. And that's what I'm saying. All right? I'm not accusing you being racist, but we are feeling racism, and this is America, and we have the right to express how we feel. Okay? And one more question to Russell. Okay, I think you misread my email. When I said that I grew up with the colonial, that means that I am used to working with the colonial people, therefore I have a thick skin. Okay? And I never said that you colonized Locke. I did not say that. All right? That's not what I meant. Okay, finally, six signatories, one letter, okay? And plus my feeling, it has to mean something. You guys cannot discount all our signatures. You guys cannot say, I am wrong, I'm crazy. You cannot say all the 6, 7 of us are crazy, okay? We stand by what we said. We stand by what we share. And you don't dictate how we feel.
Douglas, nobody's saying that. I'm curious as to what you want. You say that you sent me this thing from that guy, and I ignored it. You say it right here. I ignored it, and I was saying, what should I have responded to you? I don't understand.
Douglas, what do you mean by that? Right?
These feelings.
Wait. As soon as that, you ignore.
Well, I didn't think it was Douglas. If I didn't think it was applicable to me, why should I have responded? You had to.
So it's not applicable to you. Fine.
You had to assent it for a reason. You say that you are not making accusations. You've sent me 3 or 4 things like that in the mail.
Yeah. So I'm telling you that I felt bullied.
Good. Well, I see I didn't do anything to make you feel that way. So what was I supposed to do? I saw there was no application to me. So you can feel however it is you wish.
Yes.
But if I walk in and you feel something that of the way I walked the wrong way, I'm supposed to be responsible for that because of the way you feel. I don't feel that I've done anything to make you feel that way. So what is it that I'm supposed to respond to? You seem to think of, okay, I'm supposed to be inside your head and be psychic to know how it is that you feel, and I'm supposed to accommodate you in not saying or doing anything in a manner or a way or use a certain word or wear a certain color shirt or something like that. So to generate a feeling in you. It's not something that another can do. It's ridiculous. So
well,
if you weren't making an accusation,
say whatever you want.
If you didn't want to make an accusation, or I should have responded in a way, you need to tell me how I needed to respond to you to make you feel better after you've sent me emails.
You call me late at night. Set your feet and hang up on me. You think I want to talk
Shut
to you?
Esch up.
Okay.
I've not called you day and night. You
Well,
live
let's
in a-
everybody talk, okay? Everybody
Move on.
talks. Douglas,
Hey,
run
at
the
some
meeting.
point of order, you're just
Mute
blocking.
people. Mute everybody. One person. If you're going to have anarchy, let's have anarchy. Or you want to have organized meeting, have an organized meeting.
You
Stop
haven't raised your
people.
hand, Mr. Motlow. Okay, Miss Esch.
Thank you. I feel very sad for Joy and for Alfredo and for Douglas because I understand what it's like to be bullied by these people. And their tone of voice in this meeting is exactly how they are, only it's even worse when they're out in the street and in back on Key Street and in the gardens. I fear for my life when I go back there anymore. And I take people with me when I walk through the gardens because I've been bullied by Stuart and by Russell and by Deborah and by Motlow. And I understand exactly what you're saying. And the way that they are behaving at this meeting is how it is. And I've received the brunt of this since my kids were little. This is why my kids don't want to be in Locke anymore because they've been bullied by these people too. We call them the Key Street bullies. That's what they are. And I'm so sorry for Joy. I wish Joy would not move out. I want her to be there because she has been a bright spot at the end of Main Street. And it's really a sad thing. And I understand that they feel racism from these people too, but they don't limit it to races. They bully everybody. And I'm so sorry for you. Thank you. That's all I have to say.
Thank you. Yeah. Okay. So I think enough said on this topic, and we are going to move on. So the next item is, Bob Alexander, at the last meeting, he asked for the expenses of the LMC 2020. So I have presented those figures to him and also on the county website. So my take, I was telling him that, okay, let me share with you. So the 2020 expenses was $41,000. And when he gave a discount, our budget is about $45,000. So when we gave the 25% discount, that is about right because $41,000 is 80% of our budget. So, Brock, do you have any more questions regarding the year 2020 expenses?
That is not what I asked. What I asked was to have the 2020 put on as an action item to discuss the billing of homeowners. I didn't ask for the bill and just a spreadsheet. And I asked it for a year and was ignored. So how should I feel?
No. You asked, I sent the information to you about a month ago. And I asked you, is that what you wanted?
And I said no. What I wanted.
You say no. You say you haven't seen it. You haven't seen it. And
No.
you never answered back. I said because I came to your gallery. I came to your gallery again and again. I said, what do you want? Okay, so I presented you this a month ago. I asked for your feedback, and now you are telling me another story. I'm like, come on. I mean, is this one more layer of harassing? Okay, tell me. You said you want 2020 expenses, and I gave it to you online. I give you the breakdown. This is not online. I give you the breakdown here, and I believe I have emailed you that too. Okay. So if this is not what you want, tell me what you want.
I will talk about this subject, but you've ignored me for a year, and it was on tape, and I said it in the email. No, please put it on the agenda as an action item. But I'll talk about this because
Okay, so
I've been.
Tell me what do you want?
Is there a reason you're interrupting me?
Okay, please go ahead.
And you gave Martha 5 minutes, and then you called on her again. So I would like some time to discuss this, and then I would like the board to have a discussion and hopefully have an open mind about this. This is directly related to the most important issue you guys are facing as a board, and that's delinquent payments. You have over 60% of delinquent payments. Part of what James has said is true. It's because you haven't proceeded the correct way. But also you started off, the board in 2020 did not operate for a year. So when you guys picked up as the board, how did you start it off? You sent everybody a giant bill behind. So first off, I'd say I'm not sure that's legally correct. It's like if I have a gym membership, which I did, and they're out for COVID, yeah, they got expenses, but they don't, and they kick us out and we can't go there and they're not operating. There's no service provided, but they don't go and stick us with a giant bill when we return. Also, the billing doesn't even represent the actual cost of the time. It should only, I know you're going to give all these other costs, but it should only be the lights and the insurance for the time that was off. Instead, you billed us, I got to receive a bill for 100% of the year that was off. And for L.M.A. that wasn't operating. There wasn't cleanup. I know you talked about this Chris guy who cleaned up in the time. Well, if you accept that, then anyone can send you a bill at any time. You can't operate that way. They have to go to a board and get it approved before that. Also, the lawyer fees that were included then, you've been paid for, so you don't need to charge homeowners for that roughly $30K. So that should be on it. You need a bill that represents only the insurance and lights. And on top of that, a lot of the bills were handled incorrectly. I received a bill that didn't show any itemized. It said you owed this money without any rational itemization. Also, billing addresses have been wrong. To top it off, the town's gone through a pandemic. This town, if you understand the dynamics and you live in the town, which I do, and I've been here for a while, there are low-income families, low education, working class families. And during a pandemic, the board stuck us with the highest bill ever. Even our own government gave us money back, which never happens. So you did the opposite. So you created a problem that you're now dealing with. So my recommendation is, number one, to the board to either option one, eliminate that year off. Say, hey, we won the court case, the pandemic hit, we'll take that off, please pay up now. That's option one. Option two, go with a bill that is just the insurance and lights and say, we'll reduce it just to that and please pay up. And I will champion to everyone, please pay your assessments and pay up. They're being fair and they're caring about the community, which you are not, and you don't understand the community that's here. So that's about all I have. So thank you for your time. I appreciate it. Hopefully you address this serious and with an open mind.
Okay. Any board members comment? Mr. Motlow?
Lisa was before me.
So that's what you printed out, Douglas. And when I looked at it, what I added up from there is like the expenses you had, the Locke Water Company, SMUD, and then the first sheet minus $1,000, $2,000 paid to the lawyers came out to maybe $6,000. So I thought if we figured out the actual cost of 2020, what we actually paid, and then reduce the assessments just to reflect that actual cost. I see what Brock's saying, and it's right. It was a pandemic. People were reimbursed from the government for things, and we did not provide services. We did provide lighting and water and insurance. And if we took those costs and itemized them and then reduced the assessments for 2020, if anyone wants to consider that or has any thoughts on it.
Okay, basically the 25% discount was worked out by Joe Prassa. So Joe Prassa, what's your take?
It wasn't worked out by me. This is something we discussed in a meeting and was agreed to by all of us. That wasn't my idea, and it wasn't initiated by me.
Oh,
I was asked to implement that by you, by Diane, and by Stuart. We all sat there and talked about that.
You're a treasurer, but it's okay. I mean, yeah.
Because I was asked to implement it means that I'm responsible for that. We did that as a group.
I guess the question I'm asking is, if we did the numbers and figured out what we actually paid for that year, would the board considered reducing those assessments for 2020, even lower than 25%?
I think we should factor in deferred maintenance if we're talking along the same lines here. You know, when the discussion was, we knew this was going to be a bomb. In fact, the notices went out earlier than we had planned on. Our bookkeeper jumped the gun a little bit. We knew this was going to be a bomb. This is why we fairly quickly took 25% off and still received some backlash from that. I hear where Brock is coming from. The budget for the board is more than just lights and the insurance and et cetera. We did have a certain amount of deferred maintenance that we had to catch up on after, that should be factored in, that we had to take out of our 2021 finances to get up to snuff. I myself am willing to listen to anything rational. People that just say we shouldn't pay anything, that's just, it just doesn't make sense. It'd be interesting to see if another 25% was knocked off, see how close it comes to what was actually paid out.
That's not fair or good enough.
Well, when people say they weren't getting services, and that they are getting services now, or say Chris Fowler's rationale was I wasn't getting representation. I wonder what that representation really means. We could draw all kinds of analogies on, if you're renting a place but you go on vacation, you still have to pay rent, etc. There's all kinds of this stuff. We recognize there's an issue with collection of assessments for 2020. Brock, I don't know if what was that figure that came up with 20-something thousand for 2020?
Are you asking me?
No,
Douglas
is checking.
Oh,
okay, here you go. Yeah.
So we collected our total bills for 2020 was
41,000.
Okay, thank you. And our budget is what, a little less?
There's no budget for 2020, but our budget for 2021 is 45,000, right?
It's 45,000. So, okay, well, it's pretty clear what we're looking at there. Now we would have to involve going in and saying, well, money was paid out to B.P.E. law, but now it's been settled, It's quite a hairy question. If the assessments are lowered more, but we have a problem. There's just people that don't pay. And Brock, you were not paying assessments even before 2020. So
no, that's not accurate. And why people are not paying is because they got stuck with a gigantic bill that doesn't reflect what was going on. I'll pay my bill 100% all up to date and speed tomorrow if you just make it a bill that's about the insurance and lights. The B.P.E, why is that even in that? That shouldn't even be on the table. And you didn't even consider the community. Some of you are better off than others, but my family, my extended family, everybody suffered for this, and you haven't considered that.
Well, we did.
Well,
Yeah.
You drop it, and I'll pay it right up tomorrow.